I want to get your sense of the process so far. There's been some suggestion that this is a very defense-oriented judge, not necessarily focused in on this particular case or this particular defendant, but just generally a defense-oriented judge. I want to get your sense if you feel that might be the case.
It's not every day that I hear that a judge is defense oriented. That's a rarity. Usually judges try to come across as, I guess, fair to both sides sometimes, or a lot of times, there's accusations that maybe they are prosecution oriented. But he seems to be a little different. He's not the typical judge. The one thing that he does, and I think is great, but I am a criminal defense attorney, is the one his position on whether to call the complaining witnesses or the deceased as victims. And he's right. They are victims once there is a verdict finding the defendant guilty. Then at that point, they would become the victims. But prior to a conviction or a verdict, they are not the victims. And I agree with him. He's doing the right thing there. Now, whether you want to call them rioters or looters, I think it's the same thing. The defense should not be allowed to call them rioters or looters, because that's something, I guess, for the jury to decide within the case to see if there was enough reason. That's something that is one of the considerations. Yes, in this case, that's not something that is charged. Were these people rioters or looters? But yeah, it's going to go. It's one of the considerations that the jurors are going to have to make, and they're going to see if that in any way impacted the defendant in this case. Did he know that these people were rioters? Did he see them do something? And in addition to them attacking him, was that part of his consideration in his defense of self-defense?
Yeah, and fair enough. I agree with you 100%. But what this judge has said, and I want to get your thoughts on this, he said it doesn't really matter what Kyle knew. He didn't peg it to that. He said as long as the defense can show evidence that that's in fact what they were doing out there. So for instance, arsonists or rioters, and that's what they were doing out there, he's going to allow them to use those terms in their closing argument. And that's where I think I have a problem. I agree with you. If it's in the state of mind of the defendant that he saw them doing certain things and they want to refer to him that way in closing, that's fine. The only problem I have is that he's not pegging it to what Kyle Rittenhouse knew. He's just saying in general. What do you think about that?
Again, my argument is the same. I don't think it's fair. I think if the defense gets away with saying, you know what, you cannot call to the prosecution, you cannot call the victims at the same time, they shouldn't be allowed to call these three gentlemen rioters or looters or arsonists. It's the same thing. I let the facts fall where they may, and the jurors can decide who's a victim and who's a rioter and who's an arsonist. I think it should be left up to the jury, not defense counsel and not prosecution. It's better not to call anyone any names or give people titles. Again, let the jury make the findings of fact, not the prosecutors.
Absolutely. And that's why when you go on one side or the other, it can look like you're skewed one way or the other. All right, Lara, stand by. We're going to